The congressional hearing room fell silent. Representative Jasmine Crockett stood confidently at the podium, her burgundy suit contrasting sharply with the oak-paneled backdrop. Only moments earlier, Supreme Court Justice Amy Coney Barrett had publicly challenged her with precise criticism. Congresswoman Crockett, you've been quite outspoken on constitutional interpretation despite limited judicial experience. Perhaps you could explain the originalist view of the 14th Amendment. Barrett remarked, her tone carrying a dismissive edge. Several Republican committee members exchanged knowing smiles. The trap was clear. With her distinguished academic background and position on the Supreme Court, Barrett clearly intended to expose the freshman congresswoman's legal shortcomings on national television. But Crockett remained composed. Calmly, she opened her leather portfolio and retrieved a document. No one expected her to have. As she began to speak, Barrett's confident expression shifted to visible surprise. What followed over the next 4 minutes not only silenced a Supreme Court justice, it reshaped how America would view both women. Before we dive into this extraordinary exchange, make sure to like this video and subscribe for more coverage of political showdowns you won't see on mainstream media. Justice Amy Coney Barrett had earned an impeccable reputation within conservative legal circles. A graduate of Notre Dame Law School, where she later became a respected professor, Barrett had clerked for the legendary Justice Antonin Scalia, adopting his originalist philosophy. At 51, her rapid appointment to the Supreme Court in 2020 solidified her as a conservative legal icon. Known for her polished appearance, precise language, and firm commitment to textualist interpretation, Barrett had become a leading voice on the nation's highest court. She fiercely defended originalism, the belief that the Constitution should be interpreted based on its original public meaning. To Barrett, this was the only legitimate approach, and she often criticized what she saw as activist reinterpretations. In private conversations, Barrett reportedly expressed concern about elected officials making constitutional arguments without legal expertise. Representative Jasmine Crockett presented a sharp contrast. At 42, the freshman congresswoman from Texas had built a reputation for boldly challenging conservative judicial views. Her vibrant suits, direct speaking style, and unapologetic advocacy made her a frequent target of conservative criticism. Many Republicans dismissed her as a progressive politician lacking serious legal knowledge. What most people overlooked was Crockett's legal background. Before entering politics, she had built a successful career as a civil rights attorney in Texas, handling complex constitutional cases. A University of Houston Law Center graduate with honors, she had argued before the Fifth Circuit Court of Appeals multiple times. Yet, her legal credentials were often overshadowed by her political persona, especially in conservative media coverage. The tension between Barrett and Crockett had been building for months. It began when Crockett delivered a speech on the House floor criticizing recent Supreme Court decisions on voting rights and affirmative action, directly questioning Barrett's reasoning. At a Federalist Society event, Barrett later remarked without naming Crockett that some elected officials misrepresented Supreme Court jurisprudence for political purposes. The conflict escalated when Crockett published a detailed critique of Barrett's affirmative action opinion in the Harvard Law Review. She argued that Barrett's originalist approach ignored the historical context of the Reconstruction amendments. Though legal scholars praised the article, conservatives dismissed it as politically driven. Their direct clash became inevitable when Barrett agreed to testify before the House Judiciary Committee on Constitutional Interpretation and Judicial Philosophy. Supreme Court justices rarely appear before Congress, but Barrett accepted the Republican chair's invitation, viewing it as an opportunity to publicly defend originalism. Conservative media framed the hearing as a chance for Barrett to educate progressive lawmakers. Several outlets singled out Crockett, predicting she would be outmatched by Barrett's expertise. What they didn't know was that Crockett had spent weeks consulting leading constitutional scholars specializing in Reconstruction-era history and compiling an in-depth analysis of inconsistencies in recent Originalist rulings. The Judiciary Committee hearing was packed. Journalists lined the walls, cameras ready. Representatives from both parties filled the room early, hoping for front-row seats. The formal paneling and historic portraits added weight to the atmosphere. Justice Barrett sat alone at the witness table, a glass of water untouched. Dressed in a conservative navy suit, her hair neatly pulled back. She projected calm authority. After opening statements and rounds of questioning from senior members, the chair recognized Representative Crockett. For her 5-minute session, Crockett walked to the podium with measured confidence, placing her portfolio on the surface and adjusting the microphone. Thank you, Justice Barrett, for being here today, Crockett began professionally. I'd like to discuss your approach to constitutional interpretation, especially regarding the Reconstruction amendments. Barrett nodded, her expression neutral. Before I ask my first question, Crockett continued, I want to confirm that we both agree the Constitution should be interpreted according to its original public meaning. Is that an accurate description of your judicial philosophy? Yes, Congresswoman Barrett replied. I believe constitutional provisions should be understood as they were at the time they were adopted. Excellent, Crockett said. Then perhaps you can clarify something. In your opinion, in Students for Fair Admissions, v. Harvard, you argued that race-conscious admissions policies violate the Equal Protection Clause of the 14th Amendment, stating that its original meaning doesn't allow such policies. Barrett straightened slightly. That's correct. The 14th Amendment was intended to end government discrimination based on race, not permit it. Then came Barrett's calculated move to assert dominance. Congresswoman Crockett, you've spoken extensively about constitutional interpretation, despite limited judicial experience. Perhaps you could explain the originalist view of the 14th Amendment for the committee, Barrett added, her tone lightly challenging. Replicants smirked, anticipating Crockett's discomfort. Barrett's question was designed to highlight Crockett's supposed lack of depth. But Crockett didn't hesitate. She smiled. I'd be happy to, Justice Barrett. In fact, I've done extensive research on the original meaning of the 14th Amendment, she said, opening her portfolio. As an originalist starting point, we must look at what the amendment's framers themselves understood it to mean. The same Congress that drafted the 14th Amendment also passed the Freedmen's Bureau Acts of 1865 and 1866, which provided education and land specifically to formerly enslaved people. These race-conscious policies were enacted alongside the 14th Amendment. Barrett's expression shifted slightly as Crockett continued. Senator Charles Sumner, one of the amendment's key architects, stated clearly that it allowed positive legislation to secure equal rights for formerly enslaved people. The congressional record from the 39th Congress includes over 30 similar statements by the framers. She produced another document. Additionally, I analyzed every race-conscious federal program passed between 1865 and 1880 when the Reconstruction amendments were drafted, ratified, and first applied. There were 17 such programs, and none were considered unconstitutional by the amendment's framers. Barrett tried to regain control. Congresswoman, the specific policies of the Reconstruction Congress don't necessarily define the public understanding of the constitutional text. The Equal Protection Clause speaks for itself. On that point, Justice Barrett, Crockett replied smoothly, pulling out another document. I've compiled newspaper explanations of the 14th Amendment from 1866 to 1868. The Chicago Tribune, New York Times, and even the conservative National Intelligencer all describe the amendment as allowing special protections for formerly enslaved people. Not a single major newspaper at the time interpreted it as prohibiting race-conscious remedial programs. The hearing room grew exceptionally quiet. Journalists typed rapidly. Several committee members leaned forward, clearly surprised by Crockett's depth of historical evidence. Barrett adjusted her tone. These are interesting historical points, Congresswoman. But the text remains central in originalist analysis. The 14th Amendment states that no state shall deny any person equal protection of the laws. The text does not separate benign from invidious discrimination. Crockett nodded respectfully before answering. On textual analysis, Justice Barrett, the original public meaning of equal protection of the laws must be understood in its historical context. The phrase originated in the antebellum era, where abolitionists used it to argue for substantive equality, not just formal legal treatment. She presented a bound set of documents. I've compiled every recorded usage of the phrase from 1830 to 1868. Consistently, it referred to substantive equality of condition, not merely procedural fairness. Charles Sumner's 1849 argument in Roberts v. City of Boston used equal protection to support race-conscious remedies for previously oppressed groups. Barrett appeared increasingly uneasy as Crockett continued her methodical challenge. Justice Barrett, your own mentor, Justice Scalia, emphasized that originalism requires understanding the full historical context of constitutional provisions. Yet your Harvard opinion omits any analysis of the race-conscious policies enacted by the same Congress that drafted the 14th Amendment. How do you reconcile this omission with originalist methodology? Barrett attempted to pivot. Congresswoman, isolated historical examples don't outweigh the clear textual command against racial classifications. They're hardly isolated. Justice Barrett, Crockett countered, producing another document. This is the most comprehensive analysis to date of the 14th Amendment's original public meaning regarding race-conscious remedies. It catalogues over 200 statements from the framers, legal commentaries, newspaper articles, and federal and state policies from 1865 to 1880. The evidence overwhelmingly shows that the amendment originally allowed race-conscious policies to address historic discrimination. The room was silent. Several Republican members looked uneasy, while Democrats watched with clear interest as Crockett directly challenged one of the country's most respected legal figures on her own preferred methodology. Barrett's voice had lost some of its earlier firmness. Congresswoman, while I appreciate your research, the court must weigh multiple factors in constitutional interpretation, including consistency across different contexts. Exactly my point. Justice Barrett, Crockett responded. In your Brune opinion on the Second Amendment, you relied heavily on historical regulations from the founding era. Yet in your Harvard opinion, you dismiss Reconstruction-era evidence as irrelevant. Doesn't inconsistent use of originalist methodology suggest that factors beyond original public meaning may be influencing the court's decisions? The chair glanced nervously at the clock, relieved that Crockett's time was almost over. The gentlewoman's time, one final question, if I may, Crockett interjected. Justice Barrett, given the extensive historical evidence I've presented, would you reconsider your assertion that originalism clearly prohibits race-conscious remedial policies? The question hung in the air. Barrett, known for her rigorous academic training and experience in high-stakes legal debates, now faced a direct methodological challenge. Her response would indicate whether her commitment was truly to originalism or external outcomes shaped by other considerations. After a brief pause, Barrett replied with measured candor. Congresswoman Crockett, you've clearly conducted substantial historical research. While I don't agree with all your conclusions, I must acknowledge that the historical record surrounding the 14th Amendment is more complex than some recent opinions have suggested. A murmur spread through the room. Such a concession, particularly from a Supreme Court justice on a contentious issue, was highly unusual. Journalists exchanged quick glances, recognizing the significance. Barrett continued. The court's originalist methodology should indeed aim for consistency across constitutional provisions. Your point about the Reconstruction Congresses, race-conscious policies warrant serious consideration in our ongoing jurisprudential development. This acknowledgement, rare for a justice known for her firm positions, signaled an unexpected openness to reassessment. What had been expected as a public embarrassment for a congresswoman had instead turned into a serious constitutional discussion that prompted one of the nation's most influential jurists to publicly reconsider her stance. Representative Jerry Nadler, the ranking Democrat, quickly recognized the moment. "Madam Chair, given the importance of this exchange, I request unanimous consent to grant Representative Crockett an additional 2 minutes." The Republican chair, clearly aware of the media attention and Barrett's concession, reluctantly agreed. Crockett used the time effectively. "Thank you, Justice Barrett, for your candor. This highlights a larger point about constitutional interpretation. The framers of the Reconstruction amendments were not dealing with abstract legal theory, they were confronting the immediate realities of slavery's aftermath and aimed to create meaningful equality." She held up another document, a legal brief bearing the Harvard Law School insignia. "Justice Barrett, I'd also like to submit, for the record, an analysis I co-authored with Professor Randall Kennedy of Harvard Law School and Professor Melissa Murray of NYU Law School. It examines race-conscious remedial policies from the Reconstruction-era through the Civil Rights Movement and their compatibility with Originalist methodology." The revelation that Crockett had collaborated with two of the country's most respected constitutional scholars, both from elite institutions more commonly associated with judicial nominees, drew visible reactions. Justice Sonia, observing from the gallery, nodded slightly. Legal reporters were already typing furiously, recognizing this would dominate headlines. Barrett, maintaining her composure, regarded Crockett with a different level of respect. "I would be interested in reviewing that analysis, Representative Crockett. Rigorous historical scholarship strengthens constitutional interpretation, especially when it challenges our assumptions." Crockett nodded. "That's precisely the point, Justice Barrett. Originalism, when applied with full historical rigor, rather than selective citation, can produce results that don't always align with modern political divisions." The framers of the 14th Amendment weren't theorizing in the abstract. They were actively dismantling the legal and economic legacy of slavery through constitutional means. The chair tried to move on. "The gentlewoman's time has expired." If I may briefly respond, Barrett interjected. "An unusual step for a witness." The chair nodded. Representative Crockett, while we may continue to differ on certain applications, I want to acknowledge the depth and seriousness of your constitutional analysis. Our democracy benefits when elected officials engage with these principles at this level of sophistication. I look forward to reading your work. This final statement, a Supreme Court justice publicly acknowledging the constitutional scholarship of a congresswoman she had intended to challenge, marked a complete reversal of expectations. What began as an attempted lesson had ended with mutual professional respect and a rare public concession from a sitting justice. As Crockett returned to her seat, cameras captured the moment that would dominate coverage. A freshman congresswoman, who had just matched a Supreme Court justice on her own interpretive ground. Barrett's expression reflected professional respect and the quiet realization that her assumptions had been seriously and publicly tested. The victory was not just personal for Crockett. It sent a powerful message about who has the authority to interpret the Constitution and whose historical perspective counts in constitutional debates. In that moment, she reshaped not only her own public image, but also the broader conversation about the role of elected representatives in constitutional interpretation. The aftermath of the Barrett Crockett exchange was immediate and far-reaching. As the hearing ended, journalists crowded around Crockett in the hallway. A CNN reporter thrust a microphone toward her. Congresswoman, did you expect Justice Barrett to acknowledge limits in the court's historical analysis? With her characteristic directness, Crockett replied, I came prepared for serious constitutional discussion. The American people deserve no less when we're debating the document that shapes our lives. Within hours, clips of the exchange had gone viral. #CrockettSchoolsBarrett and hashtag ORIGINALIST, Showdown trended on Twitter. Memes contrasted Barrett's dismissive opening question with her eventual concession to Crockett's scholarship. Asterisk. Legal blogs quickly weighed in. SCOTUS blog published an analysis titled, "When Congress Challenges the Court, Barrett and Originalism," noting that Crockett's historical evidence about the Reconstruction, Congress posed a substantial challenge to the court's 14th Amendment. Jurisprudence. Asterisk. Constitutional law professors began incorporating the exchange into classroom discussions. Within days, Harvard's Professor Lawrence Tribe tweeted, "Representative Crockett's masterful originalist analysis of the 14th Amendment should be required viewing in every constitutional law class. She proved that rigorous history can yield progressive conclusions." Asterisk. Conservative media initially tried to minimize the event. Fox News suggested Crockett had ambushed Barrett with obscure historical details. Yet even conservative legal commentators found it difficult to dismiss her argument. Former federal judge J. Michael Luttig acknowledged on CBS News, Representative Crockett raised legitimate historical questions about the court's current interpretation of the 14th Amendment. Asterisk. The most surprising reaction came from scholars themselves. Professor Randy Barnett of Georgetown Law wrote in the Wall Street Journal, "Regardless of whether one agrees with her conclusions, Representative Crockett's methodology was solidly She focused on historical public meaning and highlighted inconsistencies in the court's application of originalist principles. This is how originalist debate should proceed." Asterisk. The exchange carried particular significance for black women in the legal profession. Images of Crockett, a black congresswoman methodically challenging a Supreme Court justice-inspired posts from black law students and attorneys nationwide. The National Bar Association reported a noticeable increase in law school inquiries from young black women in the weeks following the hearing. Asterisk. The impact extended even to Justice Barrett. 2 weeks later, during a scheduled speech at Notre Dame Law School, she indirectly referenced the exchange. "Originalism requires constant reassessment of historical understanding," she said, "and the Reconstruction-era poses unique interpretive challenges requiring rigorous historical investigation." Asterisk. Legal observers saw this as a significant shift in how Barrett described originalist methodology, signaling greater openness to nuanced historical analysis. NPR's Nina Totenberg noted that Justice Barrett appears to be incorporating some of Representative Crockett's historical critique into her own constitutional thinking. Asterisk. The most concrete result came 3 months later when the Supreme Court heard a case challenging race-conscious federal contracting programs. During oral arguments, Barrett asked detailed questions about Reconstruction-era precedents, questions that closely reflected Crockett's historical analysis. Asterisk. When the decision was released, Barrett's concurring opinion, while still conservative in its outcome, engaged deeply with the history of race-conscious Reconstruction policies in a way her previous opinions had not. Asterisk. The legal community immediately took notice. Harvard Law Review published a commentary titled, "Barrett, After Crockett, Evolving Originalism on the Supreme Court," analyzing how Barrett's approach had subtly shifted toward a more comprehensive historical perspective. Asterisk. For Crockett, the confrontation transformed her public standing. She was invited to deliver the commencement address at Fordham Law School, receiving a standing ovation. Law professors across the country asked her to guest lecture. The American Constitution Society named her Constitutional Voice of the Year. Asterisk. Most significantly, her reputation in Congress changed. Previously dismissed by many Republicans as just another progressive firebrand, she was now sought out by colleagues from both parties for constitutional discussions. Representative Jim Jordan, a conservative critic, was overheard saying, "I disagree with almost everything she says, but Crockett knows her constitutional history. If you're going to debate her, you better come prepared." Asterisk. 6 months after the hearing, Barrett and Crockett appeared together at a Georgetown Law Symposium on Originalism and the Reconstruction Amendments. The joint appearance drew widespread media attention. Asterisk. In her opening remarks, Barrett reflected on their exchange. Representative Crockett and I approached the Constitution differently, but our discussion before the Judiciary Committee highlighted an essential truth: historical evidence matters, methodological consistency matters, and genuine engagement with history enriches constitutional interpretation even when we reach different conclusions. Asterisk, as Crockett joined Barrett at the podium, cameras captured a moment symbolic of a new chapter in constitutional discourse. What began as an attempted public challenge had evolved into a respectful scholarly dialogue that elevated both women. Asterisk, the Barrett-Crockett exchange was no longer just a viral clip. It became a case study in how serious preparation and historical knowledge can transcend political and institutional boundaries. Law schools now teach it as an example of effective constitutional advocacy. Political science departments cite it as evidence of an evolving relationship between Congress and the court in constitutional interpretation. Asterisk. For ordinary Americans, the takeaway was empowering. The Constitution does not belong solely to judges and lawyers. It belongs to every citizen willing to study its history and principles seriously. Asterisk. In that sense, Jasmine Crockett's greatest achievement was not simply holding her own against a Supreme Court justice. It was showing that constitutional debate, and the history behind it, belongs to the people. Asterisk, if you found this story of how Representative Crockett's legal skill and preparation reshaped constitutional debate inspiring, hit the like button, and subscribe for more political and legal analysis the mainstream rarely covers. Share your thoughts in the comments. What impressed you most about this historic exchange between these two remarkable women?